For 3, there is a machinery.
There is a machinery,
There is a machinery.
by the explanation. So when
Yes.
you apply
No,
for
there's no doubt
registration-
about that.
Yeah.
There's no doubt about
There
it.
is no machinery for
No, you're
for
right.
subsection
Absolutely.
2.
This is my machinery argument is confined only
To
insofar as
subsection 2.
2 is concerned, and also to the extent that if you haven't defined a person who is ordinarily resident in Assam, I mean, then what is the inquiry going to be? I mean, it's just completely vague. What machinery can the machinery do also? This is such a crucial concept, my lord. It has to be in some days, numbers, something has to be there. Ordinary resident, it's just otherwise completely.
You have artificial definitions for fiscal legislation, like income tax.
Right.
180 days.
Yes, right.
For FEMA,
Right, right.
whatever, 270 days.
Yeah, yeah.
But these are not, in that sense, fiscal enactments. For the fiscal enactments, it normally will have a very precise definition.
Yeah,
You're conferring citizenship.
yeah.
So ordinary resident is not, it's not a term of art. It has the ordinary connotation. Somebody who
But how many days? I ask myself,
it won't be, say, ordinary residence for 2 days or ordinary resident for 3 days.
but what is it, 6 months?
You're right. There is no precise definition.
Frankly, Malaj, the law is actually to the contrary. If you with an intention move, so for example, someone like me sort of moved cities and came to Delhi. If a person moves to Delhi and even on day 5, if I've intended to move to Delhi, I would then probably have to describe myself as resident if I pack my bags, etc. at day 2.
Intention to reside.
Yes, but here, therefore, you have a situation, Malaj, please, this is in the context of illegal migrants, Malaj. It's not an ordinary person translocating within the country, etc. And so, having regard to that factual matrix, absent any criteria, any guidance, I believe it is constitutionally infirm in terms of an absence of any definition. So, Manoj, I am now done with this particular aspect as well. Now, I go to my next point. Now, here I wish to draw support from the joint communique. So, I'll just state the point. First, the point is this. The point is neither the... Sorry, one more point, Manoj, in that notion of ordinarily resident in Assam. I'll just make that point and then I'll move to the next one. This is not a concept which we found embedded anywhere, either in the Assam Accord or indeed in the communique. I'll just state that point. So that has no basis at all. That's a creation and a construct. There's no historical basis. There is no commitment in terms of international obligations or anything like that as far as this notion of ordinarily resident in Assam is concerned. Now, Manoj, I'm on the communique. Now, would your lordship please, sorry. Yes, your lordships will find that at serial number 4A, page 9398. And it's at serial number 94.
Volume?
4A.
Yes.
So if you have page 9398, to just see the second paragraph of the communique, starting with the words, during his stay. During his stay, the Prime Minister of Bangladesh addressed a mammoth gathering of people of Calcutta. He expressed gratitude on behalf of the government and people of Bangladesh to the government and people of India, especially to the neighboring states of West Bengal, Tripura, Meghalaya and Assam for the hospitality and assistance given to the millions of Bangladesh citizens and for the moral and material support given by the government and the people of India to the struggle for liberation. And then your lordships will see a further reference to that date, 25th March 1971. That's towards the foot. The Prime Minister of Bangladesh solemnly reaffirmed his resolve to ensure by every means the return of all the refugees who have taken shelter in India since 25th March 1971 and to strive, etc., etc. So I make 2 points. The first point I wish to make is, this is not specific to Assam. Well, let's be very clear on that. This communique doesn't single out Assam at all. And I make a second point, which is, in fact, the communique treats the neighboring states of West Bengal, Tripura, Meghalaya and Assam as a single set of bordering states for which the Prime Minister of Bangladesh also accords his great thanks and extends his thanks to the people of these states. So I believe this supports our submissions in 2 respects. First, this is no justification for singling out Assam. And second, in terms of what was recognized as the impact even then was all these border states. And therefore, this amounts to invidious discrimination, and it amounts to an object which is itself by its very nature discriminatory. Now I want to just, there are several other points, but I'm just going point wise, but I want to just leave a thought with you and then I'll come back to it. Please consider, if you consider it appropriate, and I'll deal with this in the context, other submission. I'll just state the point and then cite the decision later. I believe this provision ought to be struck down entirely. That's my case. But please contemplate a prospective invalidation. Think about, I'm sure your lordship will think about it the moment we make a submission in that regard. But I'm just planting the seed at this point of time. Look, it was mentioned correctly by, I don't know what correctly, but the Solicitor General at least at one point reacted to the observations made by the bench. I'm just saying it was a reaction. Maybe this is in the nature of a transitory provision, etc. But I'm not holding anyone to that particular expression. But surely, when you have no time which is prescribed at all for when you can take advantage of this, and if it were for some historic purpose from 66 to 71, surely it should not continue on the statute book and become a license and become an opportunity, a fertile ground for all sorts of local industries with regard to documentation and things of that sort, and remain on the statute book and remain on an endless beacon only to the state of Assam. So anyway, I've just made that point with regard to this. So I now come to my next submission. It really builds on the point regarding the communique. Territorial classifications we accept are valid classifications. That is a valid method for the legislature to certainly go about its job. We don't question that at all. The issue is it a valid classification here when the problem was for all the border states, when the communique recognized all the border states, when the affidavits which have been filed by the union government also record and their submissions record and accept that this is a huge problem in other states as well, which are just our neighbors, then the question I ask myself is, surely this is a case of impermissible and a discriminatory object of itself, singling out Assam for this. And when it is combined with the notion of ordinarily resident in Assam and continues to be ordinarily resident in Assam, it has impacts across generations and across decades. Now I come to the next point. So I won't take you there, but the Solicitor General correctly went through his written submissions and he pointed out 6 sets of provisions in our constitution itself, which are specific to Assam. So I'll just comment on them because that was a point which was raised. The provisions which are special to Assam in our constitution are in this regard. First, with regard to autonomy and greater autonomy to certain areas, including 6th schedule. 1. That's one type. Second, it is with respect to grants being made by the central government in lieu of export duty on jute. So again, it's something beneficial. Third, it's in respect of general grants in aid to Assam, because there are parts of the country which are found to be necessitating or requiring a leg up. Fourth, there are special provisions by the GST Council for Assam and a number of other enumerated states. There are 6 or 7 states which the Solicitor General fairly placed before you. So it's a group of states where it was felt that the GST Council, etc., has to have special regard with regard to Assam. Then it's with respect to provisions for reservations of scheduled castes and scheduled tribes. And the other special provision is for tribal administration. So broadly, these are special provisions inuring to the benefit of the citizenry of Assam, the people of Assam, and the state of Assam. They are not provisions where you set out one territory and then discriminate in it. When I say discriminate, what I mean is, your lordships have followed. I'm not saying there was some animus against the state of Assam, not that way. What we are suggesting to the court is by singling Assam out and then coupling it with ordinarily resident for all times, I mean, it's really a death blow, or it's terrible as far as the demographic and future impacts are concerned. So territorial classification we accept. All the examples given are beneficent for advantages, for certain social good and uplift. I don't believe the present statute fulfills any of those requirements insofar as the citizens of Assam are concerned. Now we have no, yes, I would respectfully submit, there is no instance of any, what I would describe as hostile discrimination. These are all beneficent classifications for Assam. There is no case, at least as which we could find, or no situation where Assam has been singled out for the purposes of something harsh or something which is disadvantageous. I'll say disadvantageous. Now I come to the next point. And the next point is really in terms of, now the reality is that this 6A is only with respect to Assam. So I'm just stating the point. I believe this by itself and nothing further requires heightened scrutiny or strict scrutiny and not the relaxed scrutiny standard which was commended by the Attorney General. I will just put it at that. Now, my lords, I'm on my next point. Now here, please consider as an alternative submission on our part, an appropriate declaration, strictly in the alternative from my standpoint, a declaration that the impugned provision section 6A be declared prospectively to be invalid. And here, I'll just give you the citation. The judgment that we are relying upon is Somaya Organics. Yes. Nevertheless, a enacted law without legislative competence remains on the statute book till a court of competent jurisdiction adjudicates thereon and declares it to be void. When the court declares it to be void, it is only then that it can be said to be, it is non-est for all purposes. In synthetics and chemicals, the invalidity of the provisions was a declaration under Article 141 of the Constitution. It was for doing complete justice that the court, in exercise of jurisdiction under Article 142, molded the relief in such a way as to give effect to the declaration prospectively. It is not possible to accept that such an order of prospective overruling is contrary to law. An invalid law has to be held to be, and has not been held to be valid. All that has happened is that the declaration of invalidity of the legislation was directed to take effect from a future date. So